This presentation will consider the definition and nature of judicial impartiality in the context of the provisions of the Judicial Council Act 2019, and more specifically, the role of the Judicial Conduct Committee to promote and maintain judicial impartiality as a principle of judicial conduct. This presentation will consider present understanding of what judicial impartiality means, and how in recent years it has perhaps become something more than merely an internal guiding principle for judges, and rather also whether a judge is impartial or not is something that is increasingly measurable because of litigation analytics, increasingly sophisticated empirical research into the judicial function, and heightened public and media scrutiny of our judges. This makes reflecting on the nature of judicial impartiality a more urgent concern for the Judicial Conduct Committee. While that committee's immediate task is to draft a code of ethics and conduct and to prepare processes for informal resolution of complaints mechanisms, this presentation looks to the committee's wider role, what it can do to proactively protect public confidence in the judiciary through promoting and maintaining high standards of conduct among judges in this era of heightened scrutiny. Section 43, subsection 2 sets out what judges and the committee must do with judicial impartiality. First off, judicial impartiality is a stated principle of judicial conduct, and to be a little bit pedantic about it, it is worth noting that the committee's first and foremost role is to promote high standards of judicial conduct and to maintain them. Their role is proactive rather than reactive, i.e., its role is not just to solve problems when they need fixing, to deal with complaints of judicial misconduct. The committee is equally responsible for doing what it can to ensure that judges are given the best chance of upholding and exemplifying judicial impartiality. As for precisely articulating what judicial impartiality is, whatever way you reflect on it, there is a certain fuzziness to the term. Charles Gardner Gay, a professor from Indiana University, once observed that it is a feel-good term, like puppies and pie, that no decent soul would denigrate. Judicial impartiality, of course, overlaps with common law concepts of objective or apprehended bias. Objective bias, according to Chief Justice Denham's ruling in the case of Good Concrete and CRH, observed whether a reasonable person in all the circumstances of the case would have a reasonable apprehension that there would not be a fair trial from an impartial judge. This suggests that objective bias is very much about perception. And by extension, judicial impartiality is to some extent about perception as well. Earlier this month, Chief Justice O'Donnell swore to execute the office of Chief Justice without favour, affection, or ill will towards any man. Impartiality here is framed negatively, defined by what it is not, to do the job of judging without favour, affection, or ill will. Impartiality is the absence of partiality. So it describes a judge who is not partial, who performs their functions in a way that is not biased, free from prejudice, and casts judgment neutrally. The bad news is that is impossible because we are human. Perfect impartiality, that is the complete absence of bias or prejudice, is at most an ideal. Impartial enough, notes Professor Gay, has of necessity become the realistic goal. And judges themselves understand and acknowledge this. For instance, Justice David Ip of the Court of Appeal of New South Wales noted that the duty of judges is to suppress their preconceptions and leanings of the mind. Note here that there is an acceptance by this judge that he has those preconceptions and leanings of the mind. It's about how a judge deals with them, manages them, rather than eradicates them altogether, or worse still, fail to acknowledge their existence in the first place. This evinces the idea that the aim is to do all one can to tackle partiality, and to do so in a meaningful, tangible sense. Impartiality must be worked on. Judicial partiality can manifest itself in different ways, in judgments, in in-court interactions, in extrajudicial statements. One could even argue at a broader level that an unrepresentative judiciary, in the sense of judicial appointments and its composition, in an increasingly pluralistic society may give rise to perceptions that as a whole, a judiciary, because it may not be representative, gives the appearance, therefore, of not being partial. On the theme of judicial impartiality, I would recommend the Australian Law Reform Commission's ongoing and comprehensive inquiry into the matter. It is a thorough piece of work that puts a great deal of order on what judicial impartiality is and why it matters. It is a ready-made body of work for the Judicial Conduct Committee here to consider. Indeed, they probably already have done so. It has well-researched background papers on a variety of themes, including, intriguingly, a background paper on cognitive and social biases in judicial decision-making, on which I presented a presentation to the Commission. What is interesting is that the Australian Law Reform Commission focuses so much of their analysis on research about the factors that make judges not impartial and how those factors can affect judges in their role and perhaps their decision-making. The approach of the Australian Law Reform Commission is perhaps the correct one because it reflects a relatively new reality. Impartiality, or lack thereof, is becoming increasingly measurable to varying levels of sophistication. As mentioned at the outset, it will become more apparent where judges may not be judging impartiality as a consequence of recent developments. Commercial tools and empirical evidence-based research will inform lawyers and the public on how judges perform. This is a visual representation of the kinds of platforms that law firms in Ireland will routinely look at, if they're not doing so already in the past 2 to 3 years or so. In tandem with this, an increasingly sophisticated literature on judicial decision-making trends has emerged from legal scholars and scholars from the social sciences. Here's an interesting example of a study by court observers on Australian judges' in-court demeanour and communication styles. I use it purely as an example of one of the many hundreds of studies that speak to judicial impartiality or the lack of it. As for Ireland, the research is at a relatively embryonic stage. Elgee and O'Malley found no evidence that trends in Supreme Court judges' decision-making correlated to the politics of their appointing parties, i.e. Fine Gael and Fianna Fáil, to any discernible degree. Recent developments in France present a very interesting counterpoint. In 2016, a French tax lawyer published data on his website about French judges' decision-making trends in asylum seekers' cases. The research highlighted wide discrepancies in rates between individual judges in their propensity to grant asylum. It was a probative piece of research, one that spoke to at least some degree of inconsistency in that particular area of law. The French Parliament, in response, introduced a remarkably sweeping law. Article 33 of the Justice Reform Act, making it a criminal offence to evaluate, analyse, compare, or predict the behaviour of individual judges, the first such ban in the world. The maximum sentence for this offence is a quite extraordinary 5 years in prison. The aim here may have been to stop the business of litigation analytics compromising the judicial function and to preserve its independence. But it speaks volumes, perhaps, that the French authorities perceived this as such a threat that the genie must remain firmly wedged in its bottle. The French approach is equivalent to burying their head in the sand. The collateral, perhaps, is that worthwhile academic research is stymied, and it may not be the best approach. The reality is that this level of granular analysis is here to stay. It is fair to suggest that this type of data has the potential to corrode public confidence in judiciaries if it could give rise to the perception of a lack of impartiality. In one sense, then, it makes sense for the Judicial Conduct Committee in its statutory role to promote and maintain principles of judicial conduct, to be proactive in this regard. Better to tackle these challenges now and not, with hindsight, reflect on what they could have done previously. At present, the committee has necessarily been broken into 3 subcommittees: to draft guidelines on ethics and conduct, to develop informal resolution processes, and to draft processes for making complaints. However, as for the next steps after its initial statutory obligations are fulfilled, this committee has an opportunity to remain highly active, to ensure that high standards of judicial conduct remain a live and dynamic issue. Judicial impartiality being a key principle to promote and maintain, the committee can proactively seek out ways to ensure Irish judges are given the tools and wherewithal to uphold and exemplify judicial impartiality as they are required to do. The committee could engage in and commission research to find new ways to collect data and information about how the Irish judiciary perform their function. That may sound somewhat unsettling, but the idea here is to proactively grasp the nettle that judging and judicial decision-making trends will inevitably become more measured and measurable in the very near future, one way or another. The aim of such data collection and research will be to provide information to the judiciary themselves so that each judge has a more detailed understanding of their role and what is going on around them. This would have to be very sensitively handled. It is also perhaps a little less disconcerting in light of the encouraging precedent that the Sentencing Guidelines Committee set by commissioning research on best practices in collecting sentencing data. The Judicial Conduct Committee could liaise with their colleagues on the Judicial Studies Committee to ensure that the types and modes of training help judges be more impartial, less biased. This is about supporting judges, something the Australian Law Reform Commission inquiry is at pains to emphasise. An excellent example of this is already here. The Conduct Committee has already worked on providing guidance as to when a judge should consider recusing himself or herself from presiding over legal proceedings. An excellent initiative. No doubt many attending the Judicial Education and Training Seminar were struck by Mr. Justice Richard Humphrey's account of the benefits he obtained from participating in role-playing exercises during training, even to the point of some discomfort on his part. As regards unconscious bias training, it is far more effective, or perhaps even only effective, when it is personalized and interactive. A colleague in Slovenia, Mojca Plesnica, recently engaged the vast majority of the Slovenian judiciary during training days in a series of experiments using vignettes based on their day-to-day work. These experiments revealed to the judges the cognitive and social biases that they were susceptible to and that they may have an effect in their judging in the real world. And those judges kept on coming back for more and more training in a similar vein. This, of course, is an initiative that strives for judicial impartiality. The Conduct Committee could also consider the issue of judicial demeanour, consider how judges communicate with litigants, both in court and in their judgments. An example might be to consider ways to systemize or scale up Mr. Justice Barrett's commendable initiative to write short letters to litigants explaining the consequences of his judgments in particular contexts. All of this is achievable and relatively cost-effective. The Judicial Conduct Committee is in a unique position to proactively find ways to help judges self-reflect on their role and help them find ways that they can, and again to borrow from the language in the Act, exemplify judicial impartiality. Finally, communication. This committee could perhaps serve as a communication strategy or strategists within the Judicial Council. If part of the statutory remit of the Council is to achieve public confidence in the judiciary, then this seems inextricably linked to how the Council communicates how the judiciary strives for high standards of judicial conduct. If good judicial conduct is as much about perception, then it makes sense for this committee to strategically reflect on how the Council and the judiciary as a whole communicates its work to the public. Perhaps these suggestions impose too high a burden on a very small group of very busy people in circumstances where resources are all too limited. And it's easy for the academic herder on the ditch, such as myself, to make such suggestions. Nevertheless, it may provide food for thought. The Judicial Conduct Committee's immediate concern is to prepare guidelines and get informal resolution and complaints processes up and running. But this presentation perhaps highlights some future directions for that committee to promote and maintain high standards of judicial conduct, including judicial impartiality, through developing resources for judges to analyze their work, to liaise with the Judicial Studies Committee to triangulate modes of judicial education and training, with the learning outcome that a judge is better placed to exemplify judicial impartiality, and finally, to communicate the council's functions and programs of work designed to improve judges in their role. This is to ensure, of course, that the Irish judiciary continues to enjoy its deservedly strong reputation.